Today, before the Supreme Court, the lawyers for the petitioner brought a motion or an application to reopen his case on the grounds that were stated in the affidavit of the petitioner. And the basic ground was that at the time that the petitioner closed his case, the petitioner did so with a legitimate expectation that the petitioner would have the opportunity at the appropriate time to cross-examine the witnesses of the respondents. Now, ladies and gentlemen, you realize that the respondents filed witness statements. They also represented to the court that they were going to make themselves available for cross-examination. So at the point in time that the petitioner closed his case, he had that legitimate expectation that he would have the opportunity to cross-examine the chairperson of the Electoral Commission in particular. Now, let me put it right that certain misrepresentations have been made to you this afternoon. It is not true in law that a party cannot be asked to testify or a party cannot testify at the trial. That is not true. That's not a true legal position. In fact, you were all here in 2018. His Excellency the Vice President, Dr. Mahmoud Bawumia, testified during the election petition that was filed by himself, His Excellency Nana Addo Dankwa Akufo-Addo, and Jake Obi-Chebi Lamte. They were all parties. Bawumia was a party and he testified. So it is entirely wrong to say that a party cannot testify at a trial. In any case, the subpoena that we are seeking to bring or to file in court is not designed to make the Electoral Commission as a corporate entity to testify or file a witness statement and be cross-examined. It is directed at Madam Jane Adukwe Mensah, the chairperson of the commission and the returning officer under the Constitution for the 2020 general elections. Now, I must put it on record that as a returning officer, she is distinct and different from the commission as a corporate body. There's a long line of decided cases on this matter, dating back to the famous English case of Solomon and Solomon. So, for them to seek to confuse Jane Mensah in her capacity as the returning officer with the Electoral Commission is, to say the least, disingenuous. And I think the lead counsel for the petitioner made that very, very clear to their lordships. And you realize that when their lordships were questioning, it was his lordship, the Chief Justice himself, who made a reference to their ruling. And in that ruling, it was that the justices took the position that you cannot compel a party to testify. And we are not seeking to compel a party to testify. We are seeking to compel Jane Mensah to testify in her capacity as the returning officer for the elections.